продовжуємо роботу.
We continue our work in Ukraine Crisis Media Center, and now our guest is Wayne Jordash, QC, Managing Partner of the International Human Rights Group Global Rights Compliance, where the report on 10 minimal steps Ukraine needs to take to effectively regulate the occupied territories.
Good afternoon. The Ukrainian draft bills aimed at regulating the legal regime of the uncontrolled territories of Crimea and Donbass, introduced to the Parliament in 2017, raise a number of concerns with regard to their substantive and procedural compliance with international humanitarian law and with regards to international human rights law. In sum, the wording and the formulations of many of the provisions of these draft bills are problematic, especially with regard to attempting to address the definition of occupation, the obligations of Ukraine, i.e. the ousted sovereign, towards the population of the uncontrolled territories, and the rights of civilians who live in the occupied or uncontrolled territories. They appear to be, or the wording appears to be, based on a presumption that a finding that the territories are occupied is a political finding or decision and strategy, rather than a political decision and strategy based on factual assessments to define the Russian Federation's responsibility to those territories, and importantly, just as importantly, what Ukraine's specific international humanitarian law and human rights responsibilities are to those citizens and civilians in those two territories. Apolitical labeling of the uncontrolled territories as occupied cannot be the sole definition for defining Ukraine's responsibilities in relation to those territories. To do so would be to, in effect, to put the cart before the horse. Even if those territories are factually shown to be occupied, this does not importantly remove Ukraine's human rights obligations. Instead, those obligations may be modified. However, Ukraine remains obliged to continue to, in the words of the European Court of Human Rights, quote, take measures that are within its power and are in accordance with international law to secure the rights guaranteed by the European Convention on Human Rights. For these reasons, understanding whether and to what degree Crimea and parts of Donbass are under the control of the Russian Federation are essential steps to designing legally compliant bills that provide the framework for legally compliant governance of the uncontrolled territories. So, in order to define the contents of any draft bill, it's my submission as part of global rights compliance that Ukraine should consider the following minimum 10 steps or 10 requirements. These steps or requirements will enable Ukraine to design law, to design regulations that regulate the uncontrolled territories, or the relationship of Ukraine with the uncontrolled territories, in a way that stays on the right side of international humanitarian law and international human rights law. The 10 steps are presented there on the screen. In sum, the first step should be to conduct a detailed fact-finding exercise. This fact-finding exercise should be designed to receive the most comprehensive and up-to-date assessment of the situation on the ground in those territories. 2, based on that detailed fact-finding exercise, to conduct a detailed assessment of the degree of control that the Russian Federation has, and a detailed assessment of the degree of control that Ukraine has also, to establish whether the international humanitarian regime of occupation actually applies, and if it doesn't, to define what the degree of control nevertheless is in relation to the Russian Federation's presence or influence, so that Ukraine can define what steps it still must take to fulfill and respect human rights obligations in those territories. Number 3, to take all possible steps to guarantee human rights. This is obviously the third step following the fact-finding exercises and analysis of step 1 and step 2. Step 4, ensure that any derogations from customary international law, international human rights law, and international human rights law obligations arising from treaties that have been ratified by Ukraine are reasonable, proportionate, and necessary. Step 5, preclude or make sure that there is no discrimination of the civilian population in those territories. Step 6, ensure an effective system of monitoring the situation in the uncontrolled territories and the recording of human rights and international humanitarian law violations. Obviously, if any draft bill is to remain compliant, that system is an ongoing system to ensure that changes in the situation in the uncontrolled territories are recorded on an ongoing basis. Step 7, ensure on an ongoing basis the delivery of humanitarian relief to the civilian population in the uncontrolled territories. It cannot be, in order to be compliant with international law, that those obligations are simply abandoned and attributed to the Russian Federation. Step 8, ensure free and secure movement of civilians in and out of those uncontrolled territories. Step 9, ensure the payment of social benefits to the Ukrainian citizens residing in those uncontrolled territories. And step 10, secure to the extent possible the property rights of internally displaced persons. So these are the 10 steps, or the 10 requirements that any draft bill needs to take on board, fully take on board, and ensure as the basis for any drafting, any draft bill. So let me briefly discuss these 10 requirements or steps. Step 1, the most important departure point: the fact-finding assessment. The sole factual basis for determining the existence of occupation is the de facto submission of a territory to the authority of the hostile foreign army. Establishing the existence of occupation thus depends on the availability of facts proving 3 things. 1, the physical presence of a state's armed forces operating within a foreign territory of another state, without the host state's consent. To establish this, the facts must show that the presence of foreign military forces is sufficient to allow it to exert and assert authority over the territory of another state or its parts. Number 2, the exercise of authority over the entire state, territory, or its parts by the foreign forces in lieu of the local government. Step 3, or number 3, substantial or complete inability of the local government to exercise its power by virtue of the foreign forces' unconsented to presence. As must be obvious from these 3 criteria, Crimea and the assessment there is perhaps not too difficult. International law is clear. Crimea is occupied by the Russian Federation. However, in relation to Donbass, the situation is more complicated. Ukraine must carry out a fact-finding exercise in order to collect proof of military presence, the potential exercise of authority by the Russian Federation, and the absence of the local authorities' consent, that is, Ukraine's consent, before concluding that Donbass is, in fact, an occupied territory. Asserting it as a political labeling is one thing. Fact-finding to conclude that it is, in fact, an occupied territory is another. In this regard, Ukraine may rely upon a wide variety of facts. But of course, those facts should be impartial, careful, accurate, and verifiable. Those reported by neutral and impartial international organizations, such as the UN Human Rights Monitoring Mission to Ukraine and the OSCE's Special Monitoring Mission to Ukraine, are obviously organizations which can be relied upon. But they are not the only source. Other reputable investigations can be conducted and should be conducted and relied upon to assess whether Donbass is in fact occupied as a matter of fact and as a matter of international law. Step 2, what happens after step 1, after that assessment has been conducted? Step 2 is an analysis step. The assessment of the degree of control that exists in relation to the foreign power and in relation to the ousted sovereign power, in this instance, Ukraine. Why is that important? It is important to ensure that the factual situation on the ground is properly understood, and that in relation to specific rights and obligations, control is properly understood. Article 1 of Draft Bill 7163, relating to the uncontrolled territories, mentions overall control. However, there is no evidence that Ukraine has conducted a detailed fact-finding exercise in relation to Donbass. There is no reflection on how Donbass is said to be controlled and to the extent that it is controlled. Draft Bill 7163 does not reflect on how the control by the Russian Federation is exercised, what powers or authority of Ukraine is limited in Donbass. It doesn't otherwise address any detail concerning the essential fact-finding exercise that would offer cogent proof of the Russian Federation's military presence, its potential exercise of authority over the separatists, nor the absence of the local authorities' consent with regard to specific areas of governance. These are the type of issues which are required to be looked at and analyzed and conclusions drawn so that Ukraine can work out what obligations are attributable to the Russian Federation and what obligations remain upon Ukraine. These assessments are necessary in relation to step 3. Ukraine must take all possible measures, having conducted this assessment, that it can take to guarantee the human rights obligations that remain upon Ukraine. Ukraine should remember and reflect in any draft bill that even if it lacks control over Crimea and Donbass, it nevertheless retains or has international humanitarian law obligations, and it remains obliged with regard to human rights to take steps to protect and fulfill and respect human rights. Its obligations may be impacted and reduced. However, it must still take, as I said at the beginning of this presentation, quote, measures that are in its power to take and are in accordance with international law to secure the rights of citizens in those territories as guaranteed by the European Convention on Human Rights. Step 4. Any draft bill must ensure or must reflect on the fact that any derogations from human rights are reasonable, proportionate, and necessary. Ukraine can make valid derogations from the European Court of Human Rights Convention, but it must do so having followed certain procedural safeguards. Any derogation must be strictly required. In particular, where a derogating measure encroaches upon a fundamental convention right, such as the right to liberty, the European Court of Human Rights will look at whether it is satisfied that any derogation was a genuine response to the emergency situation on the ground, and that it was fully justified by the special circumstances of the emergency, and that Ukraine took adequate steps to ensure safeguards against any abuse. Similar requirements must be followed in relation to the ICCPR. Step 5, any draft bill must be careful and ensure equality and preclude discrimination of the civilian population in the occupied or uncontrolled territories. In summary, in situations of occupation, the protection of the rights encompassed in international human rights instruments, such as the ICCPR, and the International Covenant on Economic, Social and Cultural Rights, shall be provided without discrimination throughout the territories. I would flag up at this stage that a number of provisions in the proposed draft bill 7163 appears to discriminate against certain categories of persons or the population, such as people residing in those territories, such as those people who cross an administrative border to and from those occupied or uncontrolled territories. These are of concern and need to be looked at and carefully assessed as to whether they discriminate against certain persons. Step 6, Ukraine must monitor and record human rights violations in those uncontrolled territories. Article 2.3 of the ICCPR and Article 13 of the European Convention of Human Rights provide for the right to an effective remedy to everyone whose rights and freedoms were violated, notwithstanding whether the violation has been committed by persons acting in an official capacity. And on the other hand, looking at international humanitarian law, as a party to an armed conflict, Ukraine must investigate war crimes allegedly committed by its own armed forces or other nationals on its own territory, and if appropriate, prosecute the suspects. Appreciating that Ukraine may have a lack of control over these uncontrolled territories does not obviate or negate the need to monitor and record human rights violations in those territories so that it can fulfill its human rights obligations and humanitarian law obligations. Step 7, ensuring that civilians in those territories have access to humanitarian relief. Common Article 3.2 to the 4 Geneva Conventions, Articles 17, 23, 55 and 59 of Geneva Convention 4, and Rules 55 and 56 of customary international humanitarian law rules stipulate that humanitarian relief actions can be undertaken when the population of a conflict-affected territory suffers from a lack of supplies essential to its survival. The parties to the conflict, Ukraine, is obliged to allow and facilitate the free passage of these supplies. In relation to the enactment of any domestic legislation that purports to regulate the relationship with the uncontrolled territories, the movement of cargo and goods, including humanitarian aid, to and from the occupied territories must be considered and must be regulated by that domestic law. States may, of course, impose rules on the transfer of dual item goods, i.e. that's goods that may be used for civilian use but also may be used for military use. However, the state must ensure that any restrictions are based on fair motives and are reasonable and necessary. Coming to an end. Step 8. Ukraine must ensure the freedom of movement of civilians. Draft Article 10 of the draft bill that regulates the movement of civilians must ensure the free movement from and to the occupied territories. It must, whilst at the same time giving discretion to the military and law enforcement organs of Ukraine, also ensure that civilians can move, especially in situations of a lack of security. Any restriction on movement that purports to meet legitimate security concerns must not prevent civilians from moving to safety. Any freedom of movement must be carefully assessed and regulated to ensure that it abides by the law, is necessary to protect national security, public order, public health, or the morals or the rights and freedoms of others, and it must be consistent with other rights recognized by international human rights law. Any restriction on movement should conform to the principle of proportionality. It must be proportionate to the interest that's sought to be protected. What does all of that mean? It means that any attempt to restrict movement that is regulated by these draft bills needs to be carefully thought through, based on facts, based on a careful balancing of these various interests. Step 9, Ukraine must ensure the social benefits of the residents of these uncontrolled territories. Being an ousted sovereign does not remove Ukraine's obligations. And step 10, the property rights of IDPs. Both international humanitarian law and human rights instruments enshrine the property rights of IDPs. Ukraine, when enacting laws, must consider provisions that guarantee the restoration of property to IDPs upon their return after the end of the conflict, compensation for any lost property, and overall ensure the possibility that IDPs can enforce and claim their property rights effectively. So, in conclusion, these are the 10, they're not the only requirements, but these are 10 fundamental requirements that any draft bill must incorporate. There is probably no perfect draft bill. It would be naive to think that a draft bill will not be a political instrument. However, any draft bill, if it is to stand the hope of being a legally compliant bill from an international perspective, must bear in mind these 10 basic requirements. These requirements will give any draft bill the best chance of ensuring that it remains, or that Ukraine's domestic legislation remains compliant with international humanitarian law and international human rights law, and importantly, ensuring the rights of Ukrainian citizens who remain in these uncontrolled territories. Thank you very much.
Thank you, Mr. Jordash. Dear colleagues, perhaps you have some questions.
Немає запитань, дякую.
There is no questions.
Thank you.